Eaton. Oh, thank you. I forgot to mention we are recording this. So if you don't want to be seen, you can turn your video off. And thank you for putting the recording on. But Sarah Eaton is the Director of Community Inclusion and Service Program at Disability Rights Washington. Thank you for joining us today, Sarah. We're here to discuss your renter rights and also talk about disability rights as a renter. We will answer questions you might have around the end of the Seattle eviction moratorium, which is ending September 30th, and that's just the Seattle, along with what it means to be negotiating with your landlord or actively seeking rental assistance funding through Washington and King County. I'd like to take a moment to remember that we are on Duwamish people's land. We also stand with the Indigenous peoples to stop Line 3 pipeline. Please visit both the Duwamish Real Rent for your local action. And if you are able to read up and want to know more about Stop Line 3 for safety, for water, for the treaties, and for the climate, we have a link for that too. Yenny is here to provide all the links in our chat. As a reminder, LGBTQ allyship builds power among LGBTQ communities and allies throughout Washington towards economic, housing, racial, and gender justice. If you are interested in working with allyship to fight for economic and housing justice for queer and trans community, please let us know via email. We have openings for our Seattle Queer Renters' Rights Committee and our Queer Worker Rights Committee. That being said, I'm going to turn it over to Sarah.
Thank you so much, Taylor. Hi, everyone. I'm so happy to be here. My name is Sarah Eaton, and as Taylor said, I'm with Disability Rights Washington. I want to tell you a little bit more about DRW, as we are called. We are the state's protection and advocacy system. So there are organizations like ours in every state and territory, and there's a Native American disability law center. So I think there are 56 in total. We're a private nonprofit organization. We protect the rights of people with disabilities statewide. We have offices here in Seattle as well as Olympia and Spokane. Some of us are lawyers, and then we also have advocates and other folks who work on policy. We do legal advocacy, mostly impact systemic litigation, policy work, coalition building, and we also investigate allegations of abuse and neglect of people with disabilities. We have not done, there are lots of, I should say, there are lots of other legal aid organizations that do housing law. And so a lot of times that's a referral to some of those other places, but we do provide information about rights to people. And so I'm going to talk about some disability specific renters issues that might come up. I do want to give time for questions today. I also have to tell you all the disclaimers. You know, I'm not your attorney, and we don't have an attorney-client relationship based on this conversation, but I'm happy to share some legal information and maybe some referrals. If you do have specific questions, then I invite you to call up our office and schedule a phone call. You can reach our technical assistance line where we provide legal information and referrals for free. And you can make an appointment to speak with either an attorney or one of our legal interns. And I'm happy to talk to you more in that capacity. So if you do have questions today, I just want to remind you that this is not a confidential space. It's being recorded, and so don't share anything that you'd like to keep confidential. And then, of course, we don't have an attorney-client relationship, but happy to provide information. So the three topics that I wanted to talk about briefly today are reasonable modifications and accommodations, and those are kind of related. So I'll talk about those together. And then, because this question often comes up through our technical assistance line and in other community spaces we're in, I wanted to talk a little bit about service animals, because that is like I said, we get that question frequently. So just, I guess, process-wise, if you do have a question about anything I'm saying, feel free to pop it in the chat, or if you're familiar with Zoom functions, you can use the raise hand function, and I'll try and keep an eye out for that. And if we don't have time to get to your question, I will be sending some follow-up resources along with what will be coming out from Taylor. So hopefully we can answer any questions you might have. So with all that said, I think I'll start by just going over sort of the differences between reasonable accommodations and modifications as they relate to housing, because I think often they're talked about together and it may not be clear how they're different. So a modification is an actual structural change that is made to a resident's living space or to the common areas. And these modifications are those which are necessary to enable a resident with a disability to have full use of and enjoyment of the housing. It may be interior or exterior. Some examples are widening a doorway so a wheelchair can fit through, maybe installing grab bars in the bathroom. It could be adding a ramp to the main entrance to the building. Lowering a thermostat in an apartment so that it can be reached by someone in a wheelchair. Anything that physically changes the structure is going to be a modification. An accommodation, on the other hand, is a change or an exception, maybe an adjustment to a rule, policy, practice, or even to the service that allows the person with a disability to use and enjoy a dwelling. And that can also be in the person's individual apartment or home, or in a common space. So examples of accommodations are things like getting a lease printed out in large print, or an electronic version if you use a screen reader. It may be that you can pay your rent on a different day based on the day you receive your disability benefits. So say your rent is usually due, or it's late if it's after the 5th, but you get your disability benefits payment on the 5th. You may be able to ask for an accommodation to be able to pay your rent on the 6th without incurring a late fee. It could be to provide like a visual doorbell signal. If you have a hearing impairment and can't hear the doorbell, then you can get one that gives a visual signal. For folks with cognitive disabilities, it may mean you can ask for somebody to sit down and explain the tenancy rules to you in a way that is accessible and that you understand. It could be that you get a monthly reminder when your rent is due. It may even mean that if you miss a deadline, say you're applying for housing and you miss a deadline, you get to go back on the wait list instead of having to start all over. Oh, it looks like we have someone else in the waiting room. And so with the accommodations and modifications, you might be wondering who has to pay for them, which is a reasonable thing to wonder. So modifications, generally the resident is going to bear that cost. So the renter will be responsible for paying for those, but the landlord can't prevent you from doing them. So if you need a grab bar in the bathroom, then the landlord can't stop you from installing one, but you may have to pay for the installation. That could change depending on the type of property and the landlord. So if it's subsidized housing or if it's a federal housing property, it may be slightly different depending on where the modification is. If it's a ramp, an exterior ramp that everyone is going to use, that may not be up the resident's responsibility, but that would be dependent on the type of property. And then as far as accommodation and who pays for the accommodation, that is generally going to be the landlord. So you, for some things, there's not a cost associated with an accommodation, like changing the date that rent is due. There wouldn't be a cost, but for some things there could be. So, and that cost is generally going to be the responsibility of the landlord. How you go about getting these types of accommodations or modifications depends. It doesn't have to be in writing, but best practice, I recommend putting it into writing, making sure you're documenting your request. There's no magic words you have to use. You don't have to say, I'm requesting a reasonable accommodation under the Fair Housing Act for my disability. You don't have to say those magic words. You can, but you don't have to. It can be in the form of, I need to be able to have an accessible parking spot closer to my apartment because my disability, it makes it hard for me to carry groceries from my car over long distances. That doesn't say the words accommodation or modification or reasonable, but the landlord should take it as such. Like I said, it's helpful to have a record of it in writing if you need to go back to show that you actually did make the request. What can a landlord ask you after you make such a request is also a question we often get. For the most part, they can ask for some verification, but they can't ask for, what is your disability, or your diagnosis or any of your medical history. Generally, they can ask, is it for a disability? And then that's a yes or no question. And then they can ask what task or how is it related to that? How is the request related to that disability? And so they might ask for verification that could look like a lot of things. It doesn't need to be medical records. You don't need to necessarily authorize a release all of your medical records to your landlord. It may be a letter from your medical provider, but it could be as simple as saying, Sarah Eaton has a disability that makes it difficult to travel long distances while carrying anything over 5 pounds. Therefore, she needs a parking spot closer to her apartment. That doesn't disclose my disability. It doesn't disclose any of my medical diagnoses. It does disclose that I have a disability and that this accommodation is related to my disability. So you can't ask for things, obviously, that aren't related to your disability, and it may or may not be obvious, right? Some disabilities are observable and others aren't. So you may need to explain how they're related, but you don't need to explain what your disability or diagnosis is. The other part of this process that sometimes is confusing is it does require what is called an interactive process. And so it may be that you make the request to your landlord and then they have questions and they can't do exactly what you want, but they come back and say, well, the parking spot that you wanted that is closest to your apartment is actually designated for somebody else. And, maybe it's for an accommodation for them. That would be a conflict that you would have to get worked out, but they couldn't disclose that to you. So maybe they could offer, we can't give you the one that's exactly the absolute closest, but we could give you the one next to it that's one over. Does that work? And so there is some back and forth that can happen. So they don't have to give you exactly what you want as long as there's an accommodation that meets your needs to be able to enjoy and to live in that residence just like everyone else. Again, practical tip is to document that back and forth in writing. And so even if you make a request in writing and they come back to you and they like come to your door and knock on your door and chat with you or send you a text or call you and talk about it, it's always good to respond to that email or respond to that via email if you have email, or send a letter and keep a copy that just says, hey, based on our conversation on Tuesday when you came to my door, this is what I understand to be what's going to happen. Thanks. Like, and just that simple documentation helps to keep that record, even if they're not documenting it in writing to you. Just sort of having that contemporaneous record never hurts. So with that process, it may be some back and forth, and it may be that you don't get exactly what you need, what you want, but it is something that is meeting your needs. There's also no kind of no limit. Like, disabilities can change and your functioning may change from year to year. And so if your disabilities, maybe you have a mobility disability that it gets worse over time and it is further limiting your mobility, you can always go back and ask for a different accommodation. Or if the accommodation that you thought was working or did work for a while suddenly isn't working anymore, you can ask for another one. So for some people, that may mean they've been able to navigate the stairs for many, many years to get up to their second floor apartment. Even if they have a mobility disability, it's still workable for them. And then due to aging or an accident or maybe some other condition, the stairs are no longer workable. So it may be an accommodation to ask to move to a ground floor. It doesn't matter that you might have asked for different accommodations in the past and received them. If you have a new need for an accommodation, you can always ask for one. There's not like a maximum that you hit. Are there questions about the accommodations or modifications? Okay, I'm not seeing any, so I will start talking about the service animals. Service animals are an accommodation. And so all of the things I just said about accommodations still apply, but in my experience, there's a lot of confusion around how this actually works for people. And partly it's because there are two types of assistance animals. There are what are called service animals, and then there are assistance animals or support animals. Sometimes they're called emotional support animals too. So under the Fair Housing Act, an individual can request to have an assistance animal as a reasonable accommodation. It can be either a service animal or a support animal. That distinction is important because not all support animals are covered under the Americans with Disabilities Act, which is the ADA. And so there are places where emotional support animals are not allowed, but service animals are. Housing is both. You can have both in housing as a reasonable accommodation, but that often gets confusing with people because you can't take your emotional support animal into certain public spaces or restaurants, but you can take a service animal. So it gets confusing, and the way service versus assistance animal doesn't sound like a big deal, but is actually a separate designation. Just a little more detail around that. A service animal is a trained animal who provides a specific type of assistant who is trained to do work or perform tasks. A therapeutic or emotional support animal or a support animal doesn't need to be trained in the same way, and can the service that they are providing can be that emotional support. And so same rules apply. Ask for it in writing. It doesn't matter if there's a no pets policy. You can still ask for an accommodation. And generally, the landlord cannot require someone to pay extra fee or deposit as a condition for receiving this accommodation. So that's what we hear a lot, is that people say, okay, my landlord is letting me have this animal even though there's a no pet rule, but they're making me pay a pet deposit. And so it's not a pet, it's an accommodation, and they shouldn't be doing that. And there are ways that you can complain, and I can send some of that information after. What else did I want to say about service animals? Oh, confidentiality is important here, because I think service animals are often a very visible thing that other residents might see. And so they might say, hey, landlord, I see Sarah over there has a dog. I thought we weren't allowed to have pets. The landlord can't say that it's a service animal. They can't disclose that that it's related to your disability. They can and should say that, something along the lines of fair housing laws require exceptions to no pets rules under certain circumstances, and then invite them to ask for an exception if they want. Anyone can apply for, can request an accommodation, but we see that happen a lot where people see a dog and assume that it's a pet or assume that there's something, and then the landlord might disclose. So they shouldn't be doing that. That is confidential, and it's part of your rights as a person with a disability who's renting. I think that was kind of like I hit the big things that I wanted to get to, and I know there is a lot to cover, but I do want to take a second to make sure if there are any questions, I can answer them.
I do want to clarify one thing with the service animals. Though you are not allowed to be charged for a pet deposit, because it's not a pet, it's a service animal, and you're not allowed to be charged a fee at the beginning or during, but you are required to still, if the service animal does any damage to the property, you are required to take care of that. And so let's say, and this has happened, where a service animal tore up the rug a little bit in an area and it just needed a patch. They did have that patch fixed, and it came out of part of their deposit. And that is legal, because you are required to take care of the place and whatever damage your pet does to the place. Does anybody have any questions about these two laws? Not seeing any hands risen. And you can also put it in the chat box. Thank you, Sarah, for that information.
Hey, you're welcome.
I have a question.
Yes.
Can you talk about service animals or support animals on buses? Our local bus system doesn't seem to have the information about service animals.
I'm going to pop our number into the chat. That's a perfect technical assistance question, and we can do that research for you and look up and talk about your specific bus route and service provider and do that through our service. But I know Taylor has other information that's renter rights related that they want to get through. So I'll put our number in the chat, and then it'll also go out in the information after. But please call us and you can make an appointment and we can have that conversation and do some research for you.
Thank you.
Thank you. Yes, and that is an important aspect too. But we do want to, unfortunately, focus on some renter rights areas. And the next section that I'm going to talk about is around our just cause ordinance, the just cause eviction ordinance. And we are excited to say that Seattle has had a just cause since the 1990s. And now it has been statewide. So that just got passed not that long ago. And what it does is the just cause ordinance was passed state level for residents, tenants, at the beginning of the year or beginning to end of their tenancies, pardon me, by penalizing unlawful lease provisions and limited reasons for eviction. What does that mean? You can't get kicked out for an unjust cause reason. So you can't get kicked out because of being trans or being LGBTQ or liking to decorate your whole place, I don't know, gray, like I like to. So the pandemic and the eviction moratorium played a huge role in this by stating the bill passing for Washington State. And those that are struggling, it's really a month-to-month just cause eviction is around a month-to-month leases, not a year, 6 month and year lease. We are still working on that. We're hoping to strengthen that and pass that one later so that there is no more loopholes. And with all, pardon me. Sorry, I should have. So what does the just cause ordinance do? If you're month-to-month renter, there is 18 legal reasons why you can be evicted. Some of those reasons are consistently paying or some of the reasons are for inconsistently paying your rent or paying your rent late consistently, violating your rental agreement, or if your landlord wants to move into the unit, if your landlord lies to get you to move out, for example, they never actually move into the unit, you can sue them for small claims court for $20,000 or $2,000, pardon me, in damages. And then there's a complete list of the reasons why you can be asked to move, but they are the 18, and the landlord does require that they give you a notice, 30-day notice of why they are asking you to leave. And it has to state one of those 18 reasons. It can't just be, we want to evict you, and then they don't say anything. They have to state one of the 18 reasons, and typically they need to send it, I'm sorry, I misquoted. It's 20 days before the end of your rental period. Did everybody follow my bouncing around? And does anybody have any questions about that? Please.
Hi, I'm Dina Wagner, and I just wanted to reiterate that. So landlords have to give the 20-day eviction notice before, I'm sorry, that's where I got off track, before the next, would it be before the next rent payment was due?
Yes, so it needs to be 20 days before the end of your rental period. So if you are, and it's for month to month.
Okay, before the rental period. And all of this, the just cause eviction that passed statewide, that once again, this is only covering month-to-month rentals at this time, but they're still working on longer leases.
Right.
Okay, thank you very much.
The Seattle City Council just passed an ordinance closing the loophole for just cause ordinance and extending protections to tenants with fixed term leases. But that's in Seattle only. And we're trying to get that statewide, but the statewide is the month to month, and Seattle is month to month and 6 or 12-month leases.
Thank you very much. That was extremely helpful.
You're welcome. Any other questions?
Yes, I'm wondering, my daughter just continues to worry about with her mental illness and if she would be hospitalized, even though she's paying her rent. And I keep telling her that that would probably preclude her landlord from, he wouldn't be able to kick her out because she's hospitalized. So but I wanted to check that. And I know maybe it's not the right time, but maybe later on you could
If
address
she-
it.
Yeah, if she is paying her rent, there's no reason why the landlord could ever evict her. If the rent is being paid on time and all the other things are being taken care of, and as long as, it might be wise to have somebody come in and check on things to make sure there's no water flooding or any of those kinds of things, just to check the water or check the heat. And you're doing your due diligence, there is no reason why you would be evicted.
Okay, thank you.
You're welcome. Any other questions?
I have one more question. Has anyone ever ran into a situation where they were threatened with an eviction because a landlord maybe didn't approve of their culture, or maybe some of the people that came around that they were uncomfortable with, or they like a situation where something like, your lifestyle doesn't align with my values. I don't like the people that you're bringing around, or if they have children or something like that. And, has anyone ever faced that issue that you've heard of where that's been a situation, and is there protection against that?
Well, that would be one of the just cause issues. So if they're not, well, if they're not one of the 18 just cause, which I do believe, yes, we put up the handbook in the chat. And
Oh, cool.
if it's not following one of those, they can evict you just because they want to, you're not in line with their belief or culture, or you don't like the people that are coming over to the renter's apartment. If you're sharing a household and your landlord is also in your house, there are some different rules around that. If you are subleasing a room within your house, there are some different rules around that. And that gets more nitty gritty. And if that's an issue that you're hearing about or need to talk to, I would be happy to have a longer conversation around that.
Okay, thank you. Appreciate it.
Yeah. All right. So our next law, if nobody has any more questions around these.
I just wanted to just chime in really quick. Dina, just appreciate your question. And I also just want to say, I am somebody who's unfortunately been evicted. My family was evicted in 2019 prior to the just cause law expansion and change. So I have, and in my case, I had the privilege of being represented by the Housing Justice Project. So my experience, I'm somebody who has experienced eviction. It is terrible. And I'm certainly have questions kind of later on, but would like to just kind of listen and just wanted to share that. So I will say that it is a definite positive that the just cause has been expanded and changed, because in 2019, they really didn't have to give a reason. And I fell victim to that. So just want to express it.
Well, I am glad that the law has changed for that reason. And I'm sorry that you had to go through that for sure. And I'm happy to have an extended conversation. So yes, thank you for bringing that up, because it really, a lot of people were kicked out and for non-causable reasons. And this really does put the protection in Washington State, and it is across Washington State. for the month to month.
I
Again,
really appreciate it. Thank you, Taylor.
yeah. So I wanted to talk about payment plans. So I know that there are a lot of people still behind in their rent, have a lot of fear around being kicked out because you're behind in your rent. There is a option regarding payment plans with your landlord. And if you don't have a healthy relationship with your landlord, there are ways to navigate this. So I don't want it to be one of those things where I don't talk to my landlord is XYZ, and we don't have any communication other by paper. That's okay. We have remedies. So they are not allowed to kick you out if they have not created a payment plan option. You are required, they are required, and you are required to try to create a payment plan, and they cannot refuse a payment plan. It has to be within reason. And within reason could be, I'm still not working and I don't have an income. So I am filing for the rental assistance programs. And when I get that, I will have the relationship to pay you. And usually that's King County will help support, or whoever you're getting that rental assistance from will be sending the money to them directly, usually. You want to make sure that you are letting them know how you're trying to access funds for your landlord. So yes, I'm looking for work. This is how I'm doing it. My employer is bringing back employees on these dates. Maybe you are still have your job, but they're bringing them in slowly, right? So let your landlord know that. Give that information to your landlord and state, I will be making payments once these things happen. But the one thing is you are, as of in Seattle, September 30th, I believe it is, you are required to start paying your rent, the full amount. And if you can't, you need to make conversation for sure. If you can't pay your rent plus an additional because you don't make enough money, that you can still put that in your payment plan and figure out a resolve for that. You can also contact the King County Dispute Resolution Center. They are working with people, say you don't have a good relationship with your landlord. They are working with people where they will talk with you and then they will talk separately with your landlord. And it'll be this back and forth relationship that they will be having until a resolve is made. The negotiation must be established within a payment plan that is reasonably given and specific accommodations. And you must reply 14 days to your landlord regarding a proposed payment. So you propose a payment, they rebuttal, you need to reply within 14 days. It's going to go back and forth like that until you come up with a resolve. During that time, they cannot evict you if you are actively working on a payment plan process. This is part of the new Washington Eviction Bridge Program, which just started August. And did it start in August? I might be wrong on that. Might have started in July. And for this program, you must do one of these four things: pay your rent on time in full, successfully negotiate a lower rent or a payment plan with your landlord and pay this as agreed, or have an application in process for rental assistance funds. Or lastly, again, these are one of four things, live where the rent assistance program has not started yet and is waiting for more funds. Most of that is outside of King County. So if you're outside of King County, and outside of Pierce County, they have not started their rental assistance funds, and so your landlord cannot kick you out. Some other things to know, your landlord cannot charge for late fees from rent that was late due to COVID-19 between February 29, 2020 through September 30th, 2021. And if your landlord does not know about the bridge program, you can provide them with a Governor Bridge the form, what he said, proclamation, and we can put that link in the chat box. Does anybody have further questions around this?
Just a quick question, Taylor, and this may even actually be more for Sarah. I'm uncertain. But I had spoken to the Housing Justice Project a couple months ago, and it was my understanding, and please correct me if I'm wrong, it was my understanding that a formal payment plan arrangement that you've described, Taylor, does not have to be made until after the September 30th cutoff, when the moratorium in King County is up. Am I understanding that correctly?
Yes, it doesn't have to be completed. But you do want to start the process now. You don't want to wait until that time frame, because as we know, King County, the dispute and resolution, who I named earlier, dispute and resolution through King County is going to be backed up. So if you need the access to them, you'll want to start reaching out if you need that. Or there's other, Q Law is also working on this. And I believe Lavender Rights Project. So they're all working around helping support tenants. But you don't want to wait. You want to start having at least the conversation with your landlord. And there are funds out there that are being distributed. And if you could also ask your landlord if they've applied for that.
I just wanted to share one quick thing. I appreciate that, Taylor. Thank you. So in my case, what I have done is every month send my landlord an email giving them an update, right, on my situation. I was fortunate to receive the first round of the EPRAP King County rental assistance help. That was last year. I am currently waiting for them to get back to me on the second round. I will just want to share too with other tenants online that in my case, it was a little unusual where my landlord accepted the first round. So that got me in the system, right? So King County EPRAP has me in the system and my landlord as a yes, that they will accept it. The second round was a little bit more unusual, and that when I applied in May, it didn't give me like a weekly email update saying like, hey, you're still on the list, you haven't been chosen. And it also said that I technically wasn't waitlisted because I already have the yes in the system as my landlord will accept the payment. But it's taken nearly as long, like that was in May. I just want to point that out to other folks. I waited 3 months to the day, the first round, to get accepted and to pay my landlord the first time. I've waited, it'll be almost 3 months in August. So I don't know if you guys, if Sarah or Taylor, if you have any information about if it's just United Way processing those or what the time frame looks like, because that September 30th deadline is coming up for the King County moratorium to expire.
Yeah, and I don't have that answer. It's not just United Way that has those funds too. There's other organizations, and I know that it's a process, and so it can be quite a process. That's why we're informing people not to wait to start applying, to be applying, to have that conversation with their landlord, and to be outreaching for those assistants.
What would it look like, Taylor or Sarah, if, let's just say in my family's case, like we've been waiting for the second round of the EPRAP help, and if it surpasses that September 30th moratorium and they don't up it again, you know, the moratorium, is that a possibility that my family, if we, you know, because it's so backlogged or the system is what it is, I'm just uncertain, like if I commit to a plan and I begin paying rent, you know, after that September 30th, I don't want to not be eligible for the EPRAP help. It just seems a little bit sticky, in my opinion.
I understand. So what I'm hearing is that and correct me if I'm wrong, that if you start paying rent, you're afraid that you won't be on that plan anymore.
Waiting to get, right, the rental assistance,
So-
right? And it's, I just think it's a little bit fishy, and that's kind of a weird term, but what I mean
Right.
is, my concern is like, you know, we've already been waiting a couple months for the second round of help. We weren't technically waitlisted, but it is taking a long time. If King County, the city council and the mayor do not up that September 30th moratorium again, there could be a lag between when I would be expected to legally pay rent and I haven't received any rental assistance. Does that make sense?
Yeah.
So,
So a couple of things, and this is where I would recommend double checking with people like Q Law, who are lawyers. And like Sarah said, I'm not a lawyer. I do have some answers, though. You are required to pay your rent. And you can make accommodations with your landlord around that. And that's you know, if you aren't making enough right now to pay that rent, how much are you able to give? Or, you know, whatever that plan is that you two figure out. If that's, but you are required to pay your full rent starting September 30th, or, you know, the next month. And everything that's backlogged in the sense of owing, you are still on this payment plan for that and waiting for that assistance. So if you're waiting for that assistance, they can't ask you to pay for that, and they can't kick you out for paying for the past stuff. So you have a payment plan, which is, I'm on this waiting list and I've been waiting for 3 months, and I am working with King County, and that is your payment plan for the past due. Does that make sense?
it totally does. And I appreciate that. I think that, yeah, it absolutely does, Taylor. I just think it's like, because they've kind of kicked the can several times on the rent moratorium, it's gotten a little bit confusing, I think, right, for myself. And then I didn't anticipate the second round of EPRAP taking this long, because they had said, hey, you know, you're not waitlisted, your landlord's already accepted funds, you're not technically on a wait list, we'll just call you. And I even, in my case, this may or may not be helpful to other tenants, like I reached out to King County a few days ago just to verify, because you can check the status, but if the page doesn't change and it's the same information it was a couple months ago, it doesn't feel that reliable. So I actually emailed them and just said, hey, I'm just double checking that you still have me in the system and I'm waiting. Other than that, there isn't a whole lot that tenants can really do. You know, it's tricky.
I totally understand. And this has been the constant conversation that we're having with them too, that they need to update the information. And then there is that whole thought is he going to extend it now that there's Delta to also, and all those things. So we're all in the same waiting pattern. But what I will say is, as of now, what we do know is that you have a payment plan, is what I'm hearing, because you have these things going on. and, the wait list, and you are moving that part forward, but you do have to pay as long as we know currently that we have not extended the moratorium.
Yeah, that's exactly it, Taylor. I really appreciate you kind of just breaking that down. It starts to get really kind of the nuances get complex. It gets a little bit weird. And I know also when the governor's proclamation ended, that impacted a lot of people very negatively that weren't inside King County. So I have the privilege of being a King County renter, but not everybody does. So I really appreciate your assistance and guidance and information.
Of course. Does anybody else have any other questions? We're wrapping up on our last 5 minutes, and I want to make sure that people feel heard.
Taylor, I was just wondering if your contact information had been put in the chat. I was scrolling through there and I did not see that, if we did need to reach out with further questions.
Yes, I will put it in there now. And then I am also going to follow up, as we said earlier, I'm going to follow up with an email to everyone that's here and give you all this information that we've been putting in the chat. We have additional information around resources that we always put out. And then it will have my email too. And you have my email from the invite to this.
Oh.
And you're always welcome to reach out to us or Sarah if you need around the disability rights information.
Okay, thank you. My other two-part question was if anyone knows of any resources that might be upcoming in the Thurston Mason County area, or Pierce, or even Kitsap.
I do believe that we have some information around Pierce. Let me double check on that and I will get back to you. I'm going to write down your information so that I can get back to you.
Thank you.
I just wanted to chime in one last thing. I really appreciate, thank you, Sarah, Taylor, and Dave for this meeting. I really appreciate it very much. Also, just wanted to get your final comments to Taylor and Sarah regarding the importance of not self-evicting, because that is going on all over the United States. It is really scary. As somebody who's been formerly evicted, I had to fight like hell. 2 years later, you know what I mean, I'm in counseling and went through a ton of trauma, but just want to get your thoughts on that, because so many people get so scared to fight and they will try to self-evict, and it's a really horrible thing. Just wanted to get your thoughts on that.
Yes, please don't self-evict. Whatever you do, please do not self-evict. You have rights, and those are, and there's people around to help support. And as many people as we can tell, and tell all your friends and any renters that you know not to self-evict. If the, what does it mean to self-evict? Basically, self-evict is like a situation where your landlord may be making statements that you're going to owe all this money and you're going to be in debt to me, and to get it create that fear, correct? And creating the fear to make you think, well, I should probably just get out of this situation and move out. That kind of tactic is illegal, first of all. And second of all, leaving a lease puts you in more in a more negative situation. During the moratorium, you couldn't be evicted, and if you self-evicted, all of that, if you did get evicted, cannot show up on your history, your rental history. During the dates that I stated earlier of September through, February through September of 2020 to 2021. So that won't go into your history. And by making it, you have a hard stop at 6. I see that. Thank you. Just make sure you don't put yourself in that kind of situation. And if you think that you want to evict yourself, please contact allyship, Q Law, Lavender Rights, King County, Seattle Rental Assistance. There's lots of organizations that can help support Northwest Justice Project. I want to thank everybody. Dave has to go, but I want to thank everybody. Thanks, Sarah, for being here. Thank you, Dave. And feel free to send me a message if you have any questions.
Thank you all. Thanks, Taylor.